Thank you, Madam Speaker. Madam Speaker, I beg to move the following motion standing in my name. Be it resolved that this House adopt the report of the Joint Select Committee on the Cannabis Control Bill 2020. Madam Speaker, it gives me great pleasure to deliver this motion for consideration by the honourable members of this House. Madam Speaker, on the 11th of December 2019, two pieces of law came to this House in the 11th Republican Parliament. The first was the amendments to the Dangerous Drugs Act, and then the second was the 2019 version of the legislation which was referred to committee, which has produced in succession this report. The Dangerous Drugs Amendment Bill 2019 amended the Dangerous Drugs Act, Chapter 1125, and effectively we treated with the decriminalization of certain quantities of cannabis as was redefined. The report before us now considered the recommendation of this House that the Cannabis Control Bill 2019 be referred to a Joint Select Committee, and I'm pleased to indicate that that Joint Select Committee in fact was comprised, and in the first report of that Joint Select Committee in the 11th Republican Parliament, we confirmed that we had held two meetings on the January 31st, 2020 and on February 28th, 2020. At that meeting, Madam Speaker, we called for submissions from 30 different entities, ranging from the Law Association, Bankers Association, University of the West Indies, etc., right through national bodies, certain ministries, including the Office of the DPP and the Judiciary. That committee, and which report was adopted into the body of this report now before us, received submissions from 30 entities across Trinidad and Tobago. In a subsequent report of the 2019 committee, absorbed by the report before us now, two further meetings were held. One on the 13th of March 2020, and on the 6th of March 2020, and the second on the 13th of March. Unfortunately, Madam Speaker, the work of that committee came to an abrupt halt because, as is well now the case, on the 16th of March 2020, we had the advent of Trinidad and Tobago taking note of the global pandemic here locally under our public health regulations. That committee, Madam Speaker, I had the pleasure of chairing along with Minister Stuart Young, Minister Fitzgerald Hines, Minister Terence Dial Singh, Dr. Tim Gopi Singh, Mr. Rushton Parry, Mr. Clarence Rambarat, Mr. Nigel De Freitas, Mrs. Paula Gopi-Schoon, Mr. Taharka Obika, Mr. Paul Richards, and then Senator Ms. Sophia Choate of Senior Counsel. Madam Speaker, in the 12th Republican Parliament, coming through the elections of August 2020, a new committee was established, and that committee was reformulated again under my chairmanship, and that committee considered the 2019 bill reintroduced as the Cannabis Control Bill 2020. On Wednesday, the 14th of October 2020, and on Friday, the 23rd October 2020, the House and the Senate referred this matter back to Joint Select Committee, and the Joint Select Committee again appointed me as the chairman of committee along with Ministers Young, Hines, Dial Singh, members Parry, Dr. Rai Ragbir, Mr. Clarence Rambarat, Minister Gopi-Schoon, Mr. Paul Richards, Mrs. Renuka Sagram Singh Suklal, Ms. Jayanti Lakshmidial, and Mr. Evans Welch. That committee, Madam Speaker, held 18 meetings. And in that committee, we went through clause by clause of a matrix of correspondence and submissions presented by the 33 entities, 30 coming in under the 2019 Joint Select Committee, and two more submissions coming in from the Association of Psychologists and the Chief Medical Officer, in total giving us 32 submissions. Madam Speaker, the committee, in analyzing the bill before it, went through the bill in its granular detail, clause by clause, and certain amendments were recommended, which are appended to the report, Madam Speaker, as Appendix 4 in marked up version. Very importantly, Madam Speaker, the committee examined the policy considerations which drove this legislation. Now, Madam Speaker, permit me a moment to explain that we purposefully separated the issue of decriminalization in the Dangerous Drugs Amendment away from the issue of control of cannabis in its wide part, because they were at polar extremes, and we did not want to stop the advances that this country could make in terms of treating with some major issues. So from a policy perspective, Madam Speaker, I'd like to put on the record that we considered work at the Ministry of the Attorney General in the Law Reform Commission. I had commissioned a report from the Law Reform Commission. It is entitled A Policy Document on the Reform of the Laws Related to Cannabis Use, Possession and Supply in Trinidad and Tobago. We had done a decriminalization of marijuana public consultation aspect. And Madam Speaker, coming out of that, we had a report. I should tell you, Madam Speaker, that that report involved a significant amount of public consultation. 6 public consultations with 1,135 persons attending, and we took advantage of receiving and publicly discussing judiciary statistics, forensics statistics, and the CARICOM report, which is the third limb of policy, being the report of the CARICOM Regional Commission on Marijuana 2018, entitled Waiting to Exhale, Safeguarding Our Future Through Responsible Socio-Legal Policy on Marijuana. That was chaired by Professor Rosemary Bell Antoine. Now, Madam Speaker, what is material to note is the statistical information underlying this report, which the committee has spoken to. And Madam Speaker, in looking at the statistics, permit me to put on the record the following. Number 1, statistics at the judiciary's position, including prisons information, and very importantly, Madam Speaker, statistics coming from the Forensics Institute. Now, Madam Speaker, quite interestingly, the reason why I'm referring to statistics produced in 2019 is that today I have incredible statistics in my hand coming from the judiciary as at this year. And for the first time in my recollection of parliamentary debates, we are able to say we hit the target. And I'll tell you how, Madam Speaker. Madam Speaker, the demonstration of statistics which the committee reflected upon and which were posted to the website of the Office of the Attorney General and Ministry of Legal Affairs shows that between the period 2007 to 2018, 84,668 cases came before the magistracy. Under the Dangerous Drugs Act, for possession of marijuana, possession for purposes of trafficking, cultivation of marijuana, and gathering, 71,964 of those cases were for possession of marijuana alone. In the law term 2017 to 2018, there were some 9,553 marijuana-related cases, with 8,316 being for possession of marijuana alone. Madam Speaker, in the period 2010 to 2018, we statistically demonstrated approximately 500 persons each year were put into remand. In that entire period, 3,429 persons were remanded. We have had, as at today's year, 28 years of the Dangerous Drugs Act. And Madam Speaker, when we looked at the statistics inside the prisons, and we note, Madam Speaker, when you go down to male-female distribution, when you go down as granular as ethnic distribution, a vast majority of our citizens between the ages of 20 to 34 were incarcerated by the thousands in charges as well. 20 to 24, marijuana possession statistics, that age group, in the year we're looking at, in the range of years, putting the age group 20 to 24, 2,848 people. 20 to 25 to 29, 2,783 people. In the age group 30 to 34, 2,466 people. Now, Madam Speaker, a very interesting statistic. We did a racial disaggregation to demonstrate that it was in our East Indian and African distributions, we found that we were significantly in disproportion. And when we did a socio-economic disaggregation, we effectively saw that our poorest and most disenfranchised males were being incarcerated. Now, Madam Speaker, one of the driving forces, therefore, came in a simple submission. In the magistracy, we were dealing with 144 to 146,000 cases per year. And for years, this country cried out, we need more courts, we need night court. And we went as a government and said, we need to disaggregate what is in that court. And we pulled the figure of 8,500 marijuana cases alone per year. And by causing the decriminalization under the Dangerous Drugs Amendments as the companion law to the policy underwriting this report before us, we have seen, Madam Speaker, an important statistic which I will come to in a second. Because of the 146,000 cases per annum in the Magistrates Court, we removed 104,000 by applying the U-turn demerit points system, removing motor vehicle and road traffic out, and 8,500 cases we targeted in terms of marijuana. Now, Madam Speaker, permit me to put one more fact on the record before I come to the current statistic. Back in 2019, when this report was being commissioned by the Referral to Joint Select Committee, the Forensics Division told us, according to their data, if they looked at the cannabis cases for 2018 and they separated it out, the vast majority of the 753 cases were for possession under 30 grams. But listen to this. It was noted by the Centre that once the legislative reform comes into effect, the number of cases before the courts should decrease by 66% and notably will decrease by 74% upon decriminalization under 60 grams. That's a very bold submission to have been made in 2019. Now, Madam Speaker, we requested information from the judiciary, and I am very pleased to now inform that as a result of the decriminalization of marijuana, the judiciary has reported in the statistics in relation to decriminalization of marijuana, in a document I obtained from them in February 2022, that there has been a 78% drop in the average number of drug-related matters filed annually at the magistracy, from 6,600 odd to 1,400 odd. A drop in a monthly total of 551 matters to 114 matters. Now, Madam Speaker, what does that mean in the context of the report before us? It shows that with the courage to adopt reform as it relates to decriminalization of marijuana, we have been able to divert the court's attention away from marijuana-related matters. We have dropped the statistical information by 76%, Madam Speaker, on average, and therefore less people are now before the courts in the jeopardy of losing their lives and reputations. So, Madam Speaker, in this report, we come to consider, in the published information now before us, laid in the House on the 9th of June 2021, laid in the Senate on the 11th of June 2021, your committee has had the pleasure of reporting on the legislation proposed. The Cannabis Control Bill, Madam Speaker, is an interesting one because it's the other side of decriminalization. It's the legitimate and lawful exploitation or production or commercial realization, Madam Speaker, separated between medicinal or therapeutic use and religious use. Madam Speaker, what time is full time?
3:21.
Thank you, Madam Speaker. Madam Speaker, to get to the root of this bill, it's important for us to remember that prior to 1885, cannabis, or ganja as it was referred to, was completely legal. You could use it medicinally, recreationally, and industrially. In 1885, we had the Ganja Cultivation Licensing Ordinance, where we licensed cultivators and we put tariffs on goods. In 1894, we had the licensing of medical practitioners to keep and sell ganja. In 1899, we had the Ganja Ordinance of that year, which separated prepared ganja for medicine from unprepared or smoking. Now, smoking ganja fell under the Opium Licensing Ordinance of 1879, and you could sell imported ganja for retail or recreational purposes. Madam Speaker, in 1915, we had the Ganja Ordinance. And that allowed cultivation in Trinidad and Tobago under the Director of Agriculture. There were specific regulations for importation, packaging, sealing, taxing. But in 1928, we had the Dangerous Drugs Ordinance, which repealed the Ganja and Opium Ordinances and entered international conventions. The Geneva Convention, its first one, which ensured a licensing regime for importation above 20 pounds. It was after we got to the 1960s, where we had the UN Single Convention on Narcotic Drugs, 1971, the UN Convention on Psychotropic Substances, 1972, the protocol that amended the Single Convention, and 1988, the UN Convention against illicit traffic in narcotics and psychotropic substances, that we saw the criminalization of marijuana, or ganja as it was referred to. Madam Speaker, in 1994, we produced our Dangerous Drugs Act, Chapter 1125. And interestingly, in our customs law, we still have reference in Act number 22 of 1938 to ganja and to how customs duties, etc., were then permitted but then disallowed. What's interesting in our Dangerous Drugs Act, an act of, Act number 38 of 1991, is that under Section 4 of the Act, the Minister of Health has a responsibility to make regulations for licensing, import, export, diversion, sale, manufacture, to issue licenses for cultivation, gathering, production, etc., to name ports of entry, to deal with packaging, etc., to authorize furnishing to masters of ships, and to prescribe records. And in Section 5 of that law, we have the disapplication. There is no criminality for certain persons under licenses, medical practitioners, dentists, veterinary surgeons, etc. So our law since 1991 has contemplated the legitimate exploitation or cultivation of marijuana, now referred to as cannabis. And Madam Speaker, today the report before us recommends unanimously by all persons in the Joint Select Committee, there's no minority report, we recommend that we create a cannabis control authority. Madam Speaker, this is no small move. Trinidad and Tobago has the advantage of a very advanced intellectual property system, where geopatenting, where patenting of the DNA of the type of cannabis that we grow is an option. And in looking at the legislative examples that we did, Canada, St. Vincent and the Grenadines, we looked at Antigua and Barbuda, we looked at Jamaica. Our committee considered and invited persons from these authorities, Barbados, etc., to come and speak to the committee And I wish at this moment to say that as chairman of the two successive committees, the work of the committee was very vigorous and was very interesting. It was certainly a joy to have chaired the committee, Madam Speaker, because before us is a recommendation for very robust law. Madam Speaker, if you turn to Appendix 4 of the committee's report, and we look at, in convenient form, the amendments that we propose. Madam Speaker, we are looking at a bill which is comprised of 68 clauses with 9 parts. I should flag that there are a few minor amendments that we wish to propose at committee stage when the bill is read a second time for consideration by the House, tidying up provisions that we have observed at the Attorney General's office, Madam Speaker. But Madam Speaker, what we do here is to take the very best example of a statutory authority and put it to work in the context of our law. Now, from an overarching perspective, Madam Speaker, we're looking at creation of an authority. We're looking at certain conditions, its management, its ability to borrow, its financial arrangements, its reporting structures to Parliament and otherwise. But when we get, Madam Speaker, to the licensing aspect, it is important to note that the committee recommends that we have 2 categories of licenses. Licenses for medicinal purposes, which are 8 in number, and licenses for religious purposes. And that is to be found in Clause 29 of the bill. When we look at the type of licenses for medicinal, therapeutic, or scientific purposes, it's important to note we have a cultivator's license, a research and development license, a laboratory license, a processor license, a retail distributor license, an import license, an export license, and transport license. That category of licenses proposed in Clause 29 applies to the medicinal, therapeutic, or scientific purposes. It's defined, medicinal purposes are defined in the interpretation section. It's tied in to Part 5 of the bill, beginning at Section 42, Clause 42 of the bill. That's the medicinal aspect. And separate from that, the different packages of licenses available for religious purposes, which is to be found at Part 6 of the bill, beginning at Clause 47. The religious licenses are 5 in number. A cultivator religious license, a dispensary religious license, an import religious license, an export religious license, and a transport religious license. And then the bill proposes that in this licensing regime, that there's certain types of licenses that flow with the grant of a particular license. For instance, the transportation and other forms of licenses that flow with it. Very importantly, Madam Speaker, the bill proposes who can receive a license. And if we look to Clause 30 and we look to the eligibility for a license, we specify you must be an adult, because this bill recommended by the committee proposes that children must be strictly protected. I remind, Madam Speaker, that our Children's Act number 12 of 2012 is in operation, that Section 35 of that Act, exposing a child to a dangerous drug, applies strictly, that Section 36, giving a child a dangerous drug, applies strictly, that Section 37 of that Act, that is where a child is used to buy or sell or deliver a drug, applies strictly, and that there is parental responsibility for the child. And Madam Speaker, when we look to the persons, you must be an adult in eligibility, a citizen of Trinidad and Tobago, a permanent resident of Trinidad and Tobago, or a citizen of the CARICOM member state other than Trinidad and Tobago. And lastly, you can be a company, a firm, a partnership, or cooperative society. Let me explain this. We are in the realm of the CSME. Our neighbors in the CARICOM are ahead of us in the game, because quite frankly, prior to this government, no one had the courage to treat with the decriminalization and the legitimate exploitation of cannabis. When we contemplate the CSME run, we have to look at the fact that Barbados and Jamaica, Antigua and Barbuda, St. Vincent and the Grenadines are already in full production. They are exporting. They are now meeting the world with the ingenious products that are very carefully managed. When we look to the fact of CARICOM citizenship, therefore, in eligibility in Clause 30, it's an important requirement. When we get to a company, firm, partnership, or cooperative society, or a religious organization, which must be registered under the Non-Profit Organizations Act, we mandate that you must have a 30% local content. Now, Madam Speaker, the All Mansions Rastafari entity came to us, and we looked at the push in Jamaica where those who had fought for the decriminalization of marijuana for years complained that they were put out of the industry, that they were denied the opportunity to form cooperative societies and to benefit from, quote unquote, the herb. Madam Speaker, in looking at the economic opportunity for our own citizens, including cooperative societies, we found it prudent to put a mandatory local content factor. Why? The mind and management of the best in class for cannabis production in the safest environment, we must accept, comes from foreign jurisdictions. But, Madam Speaker, our people, the All Mansions Rastafari, people who have persevered in calling as advocates for decriminalization and legitimate exploitation, they too must have a voice. And the government has been, with great pleasure, put in a position of standing as an advocate for equal opportunity and fair chance for those who encouraged us to have the courage to do this in a responsible way. Madam Speaker, in terms of the other side of the coin, because this is a very heartfelt issue, there are people that feel that we should never decriminalize cannabis. What we looked at when we looked at the prisons data, when we looked at the court data, we saw that our citizens were being locked up, thrown away, and lives ended. And what was by far a better opportunity for us as a policy consideration in this report was to ensure that we control the management of it. Children must be protected. Use and smoking in a public place is not permitted. Religious purpose is strictly organized, and it is strictly organized, Madam Speaker, under the Non-Profit Organizations Act, by the fact that you must file an AML CFT PF questionnaire, an anti-money laundering, countering financing of terrorism, and proliferation financing. You must have full financial disclosure. We protect the financial disclosure aspects by creating a public register for things that can be inspected and a private register for the sensitive personal information, Madam Speaker. Madam Speaker, we ensure protection for our children and those vulnerable in society by ensuring that there is a rigorous inspection regime. First of all, Madam Speaker, as a material point, the committee points you to the fact that you have to, as a term and condition of license, if you look to clause 35, you must be registered. You cannot have a license for a dwelling home. It must be in a commercial aspect. You have to obey the terms and conditions of licenses, but you must strictly consent to the entry of inspectors on any premises specified in the license. And then when you get to the inspection program, Madam Speaker, you get to Part 7, Part 8 of the bill under inspections, you get to Clause 59 of the bill, right through, Madam Speaker, to Clause 64, you will see that there is a regime for inspection that allows full access inspection. In other words, if you don't want to consent to rigorous scrutiny, don't apply for a license. We, of course, take in aid the use of access to premises via inspectors because you have consented as a condition of your license, Clause 35 and Clause 59 onward added together. But, Madam Speaker, we preserve very strictly in Clause 64 the ability for a magistrate being satisfied on information on oath that there are reasonable grounds for the grant of a warrant, Madam Speaker. And therefore, we are not in any form or fashion abandoning what works for us. In fact, we're doing the opposite. We're bringing it to life in the structures of taking conscious reflection in the law in clause 64 of the use of a warrant for entry and for purposes. Madam Speaker, when you get to the concept of medicinal versus religious use, I'd like to take you, Madam Speaker, to part 5 of the bill at Appendix 4 of the report, beginning with clause 42, medicinal cannabis. And you will see, Madam Speaker, that we have very strict conditions on parental involvement, persons with responsibility for the child involvement. We ensure that the circumstances are such that if you are to be at all a user of cannabis under the cannabis control position, you must comply with the medicinal cannabis provisions. A person who uses medicinal cannabis, and that is defined in the interpretation section, without being authorized to use medicinal cannabis by a prescription or recommendation from a medical practitioner, commits an offense. That is both summary and indictable. A parent or guardian or person with responsibility for a patient who is a child, stick a pin, there's an amendment going to be proposed there, shall obtain a certificate in writing from a medical practitioner certifying that the use of the medicinal cannabis is necessary in the case of that child, and the parent or guardian shall consent in writing to the use of the medicinal cannabis by the child. And then there are very strict limitations on dosages. You cannot have a recommendation or prescription which involves filling over 30 days. There must be a constant cycle. The medical practitioners are obliged to keep very strict records. Those records are subject to call. They must be submitted. They can be anonymized in certain circumstances so that the private information of patient confidentiality is preserved. Madam Speaker, we have very strict provisions, if you look at clause 45, with respect to caregivers, because, Madam Speaker, as I reflected when I piloted the Dangerous Drugs Amendment in 2019, I recall vividly the experience of that dearly beloved Senator then, Corinne Baptiste McKnight, as she wrestled with cancer. God rest her beautiful soul. And as I visited her at Vita's house, telling me openly, pursuant to medical prescription, that the only thing that eased her pain was a smoke of marijuana. It dawned upon my mind, as a non-user of marijuana, a non-user of cannabis, that the relief factors brought about by this have very, very immediate concerns. But, Madam Speaker, equally so, we have tales of people who have committed suicide under drug use, who have lost their lives to uncontrolled and unsupervised cannabis, and finding the balance here requires us, as this law has proposed, to have dose limitations, caregiver limitations, strict rules for medical practitioners. Madam Speaker, if you go to the dispensing of medical cannabis, it's where you will find in clause 46 what I'm referring to, the strict record keeping, the prescriptive positions that are given by law, the register to be kept. Then we go, if you look at part 6, to cannabis for religious purposes, it's here that we're very strict about sacramental dispensary, an absolute prohibition against any form of profitable engagement for sacramental dispensary. Children cannot be exposed in the sacramental dispensary aspects. If you're going to create a religious organization, because what is the freedom of religion in this country as recognized in the Constitution? It's a very amorphous thing. It is not defined what a religion actually is. What is Christianity in law? It may be in natural law, it may be in canon law, but it is not certainly described in the laws in any books of a country in any prescriptive way other than in marriage acts, etc. It's the same thing for Islamic law, Sharia law. It's the same thing for the canons of any other faith and prescription. So what we did here in the religious purposes part 6, we mandated that you had to be registered under the Non-Profit Organizations Act. And there are very strict requirements for that, Madam Speaker. That is a dynamic piece of law which I, as representative in the Attorney General's office had the pleasure of passing, and that we have now seen in full operation outlay with some 11,000 non-profit organizations being registered between the old provisions of law and the new provisions of law. Madam Speaker, when we look to the registers, it's what I was referring to earlier in part 7, and in the registers we're referring to the need for a private register to deal with the sensitive personal information. It's available to law enforcement. It's available to the supervisory authority of the Financial Intelligence Unit or other entities. It's available under court order, but it is not available to the public because it involves sensitive personal information within the data protection principles recognized by our laws. On the other hand, the public register is available, and the public register includes the type of registries for the type of licenses that we have. Madam Speaker, when we get to the manner in which the law is administered, we look to the approval of the license, the variation of the license, the suspension of the license, the revocation of the license. There is a neat, logical distribution in the bill, which is annexed as Appendix 4 to the report, which says how much time is required in consideration, the fact that you must give public notice in respect of applications, you are to invite objections to applications, you are to consider those objections, you are to rule upon it, you are to ensure that a fair opportunity is given to the applicant to respond to objections, and in the event that the authority should decide to reject an application, or in any event where there is a disagreement, from the applicant's perspective, Madam Speaker, I would like to point you to Clause 67, which entrenches that a person who is aggrieved by a decision of the authority under this Act to refuse to grant or renew a license, to suspend or revoke a license, or to impose a civil fine may, within 30 days of being informed of that decision, appeal to the High Court. So we have preserved due process, moving from the quasi-judicial entity, which is the authority, into the High Court, preserving due process. Very importantly, Madam Speaker, we allow for administrative fines to apply. And I signal that when we get to Clause 65, there's an amendment we propose which will harmonize what we did most recently in the Special Economic Zones legislation with this particular law. This law was drafted before we settled the Special Economic Zones law, so there's an amendment that we propose to circulate at committee stage on the second reading of the bill itself. But in the administrative fine position, we are taking advantage of what we call Recommendation 35 of the Financial Action Task Force, which says that you ought to have an alternative to simple locking up people or charges. We also propose, in harmonizing this section, to remove the reference to the mandatory consent of the Director of Public Prosecutions, to bring it in line with what we passed as a Parliament in the Special Economic Zones legislation. Madam Speaker, if you jump backwards now into Appendix 4 and we go to the authority itself, very important to note that the authority is in Part 2. It is to be called the Trinidad and Tobago Cannabis Licensing Authority. It has very broad functions, Madam Speaker, advising the ministry, grant, amend, suspend, revoke, cancel licenses, set terms and conditions, inspect, monitor, access the handling of cannabis pursuant to licenses, take enforcement measures, establish and maintain registers, establish and maintain electronic database and other tracking of handling of cannabis matters electronically, establish and maintain an electronic register of medical practitioners, patients, and caregivers. Establish and maintain other registers and databases as may be prescribed. Assist with the provision of analytical services. Establish programs for the distribution of educational materials, training programs, etc. Ensure proper disposal requirements. Enter into agreements and arrangements. Perform such other functions. In doing this, Madam Speaker, we're ensuring that there is a vertical and horizontal integration of services. Very importantly, the authority, when it is comprised, will have the task of bringing to life regulations I refer you to clause 68, where the authority may, with the approval of the minister, that's the Minister of Health, make regulations generally for carrying this act into effect. And it is those regulations that will be the binding glue. By the way, the regulations are proposed to be done under affirmative resolution, under clause 68.3. Why? It's so serious a matter that we're treating with a scheduled dangerous drug under the Dangerous Drugs Act in a different way. We want to make sure that the full attention of the Parliament is brought to bear in the regulations that are to ensue. Madam Speaker, the board itself is comprised of 9 persons. There's a CEO that is ex officio participant but has no voting rights. We ask for the fields of law, management, finance, accounting, medicine, scientific research, agriculture, law enforcement, education, and drug rehabilitation. Stick a pin. Madam Speaker, this government birthed in the legislative amendments we did in the criminal proceedings route and the children's court. We birthed a drug rehabilitation court, which the judiciary has very successfully operationalized, Madam Speaker. And that is something to take our citizens or persons who come before the court, and very importantly, our children, out of conflict with the law, not just by locking them up by the thousands, as the data demonstrates, but instead by rehabilitating persons, Madam Speaker. Madam Speaker, the board has the flexibility of meetings, etc., in the usual conditions. It has staff that it can employ. It has committees that it can employ. It has experts that it can employ. Madam Speaker, we have a strict obligation of confidentiality, and we have a strict obligation in respect of conflicts of interest. Because in drafting the provisions, we needed to make sure that you could not participate either as an employee or as a member of the board of directors if you have a commercial or other pecuniary or contingent interest in the handling of cannabis, handling not including the lawful medicinal use of cannabis, which can be done by prescription. If you have a conflict of interest, you must declare it. There must be annual declarations to underwrite the confidentiality provisions and the conflict of interest provisions. Madam Speaker, accounts are to be produced, reports to Parliament are to be produced. Parliament is to receive those things within prescribed time frames. And Madam Speaker, in a nutshell, therefore, we have taken the law in relation to dangerous drugs. In 2019, we had the courage to decriminalize cannabis. In 2022, I can stand before you now and say there has been an over 70% drop in matters coming before the magistrates' court. That is no small achievement. Madam Speaker, many of my constituents tell me of the relief that they feel in knowing that they don't have to look over their shoulder to be arrested. Madam Speaker, we are in that end of the equation today capable of speaking to absolute success, which is still ongoing, but today we are saying to the nation, let us do like the rest of the world has. Let us carefully manage the lawful exploitation of cannabis, cultivation, production, etc., under license. Let us look after the most vulnerable, our children, etc. Let us categorize it into medicinal use and religious use. Let us come up with 8 licenses on the medicinal side, 5 on the religious side. Let us introduce law enforcement. Let us have a rigorous system of inspection. Let us have consent. And let us allow the international narcotics control agencies who have already looked at our position and have told us that we are not offending any of the international rules in the conventions. Let us look at giving Trinidad and Tobago a fair opportunity. Madam Speaker, as the chairman of this committee, I wish to say that it was a sincere pleasure to produce work of this kind. I wish to thank the legislative drafting department at the Attorney General's office and the Secretariat of the Parliament for the very hard work that was put into this, including in particular, Madam Speaker, the work that the CPC himself lent to this exercise as he sat in the committee with us. We have had a good product now tabled by way of report, and Madam Speaker, promptly at an end now, I beg to move.
Honourable members, I will now propose the question for debate. Be it resolved that this House adopt the report of the Joint Select Committee on the Cannabis Control Bill 2020. Member for Miaro. Member, you're reminded you have 45 minutes, full time.
Madam Speaker,